Kevin Hogan, Landstar.
All right, we're going forward in cause number DC181428. We're a motion to quash.
And Judge, I'm sorry to interrupt. This is Morgan McFeeters on behalf of Prestonwood Pain Clinic.
Okay. Great. Thank you, Ms. McFeeters. Let's go ahead and proceed with the motion to quash. I'll let Ms. McFeeters start.
Sure. Thank you, Your Honor. May it please the court. Prestonwood Pain is one of the treating physicians for this plaintiff in this case. They have previously produced all of the medical and billing records pertaining to their treatment of this plaintiff. And they have also provided, as I understand, a affidavit regarding those services pursuant to 18001 of the Civil Practice and Remedies Code. And based on my review of the court's docket, it looks like plaintiff served that 18001 affidavit on the defense, and the defendant moved, or rather provided a counter affidavit pursuant to 18001 regarding those services that Prestonwood Pain provided. And plaintiff moved to strike that affidavit, which the court granted that motion and did, in fact, strike that counter affidavit. So since then, defendants have served two identical subpoenas on Prestonwood Pain, whereby they are seeking all kinds of extensive, invasive discovery regarding Prestonwood Pain's internal business operations, their billing records pertaining to other unrelated patients, and their historical relationship, quote, with plaintiff's counsel. And it's my understanding that they withdrew the first of these two subpoenas, but they are essentially identical. So we have asserted objections and filed a motion for protection seeking to have the court quash both of these subpoenas in their entirety. Essentially what it seems like the defense is getting at is they are attempting to determine, among other things, what a hypothetical amount would have been paid if this patient had used other kinds of public or private health insurance. This patient did not use health insurance, did not present health insurance to Prestonwood Pain, and instead they were treated pursuant to a letter of protection. So all of the additional information that the defendants are now seeking from Prestonwood Pain, as well as I understand it, additional other medical providers that also treated this patient, is completely irrelevant. It would be inadmissible. It's reasonably targeted to lead to the discovery of admissible evidence. But even further, Judge, I think one of the most important things for the court to consider here is that because the court has already struck the counter affidavit of defendant's experts, they are procedurally barred from offering any additional evidence at trial to challenge the reasonableness and necessity of these bills. So even if the court were to find that any of this is even slightly relevant or permissible, the potential benefit, however slight, of any of this evidence is far outweighed by the burden that it would impose on my clients and these other providers to respond, because ultimately they will not be able to use any of this at trial because they're procedurally barred from doing so.
I can't hear.
Ms. Jobin, do you want to add anything?
Your Honor, I mean, it's essentially the same. I mean, there's 27 questions with 37 separate categories of requested documents. And as Ms. McFeeters stated, it's seeking irrelevant information, and it's not likely to lead to the discovery of admissible evidence based on the fact that the counter affidavits were struck, and it's unduly burdensome and harassing. And any agreements between non-party providers and Everseen Witherite or the Witherite Law Group and health insurance rates and information about what other patients would pay and those kind of reimbursement rates would be inadmissible under Texas Rule of Evidence 403 and under the collateral source rule. And the information that's being requested is proprietary. And it's not reasonably tailored to the needs of this case, and it doesn't have any, they're not going to be able to use it at trial. So that's our position, is also that we would move for a protective order and that these deposition by written questions be quashed.
Mr. Strauss, I'm inclined to quash all of this, but if there's something in particular you're really looking for that maybe I'm missing, I don't usually let in letters of protection or any of this other stuff. I think it all goes to collateral source. And so I'm not sure what you're kind of getting at here.
Well, Your Honor, the crux of this particular, I believe both Ms. Jobin and Ms. McFeeters, respectively, are missing the real issue here today. These DWQs are issued seeking relevant material information that pertains to the only legal standard that plaintiff must prove at trial. To be recoverable, plaintiff's medical expenses must be reasonable. These discovery subpoenas that were issued to the 5 treaters at issue today only pertain to whether or not plaintiff's medical expenses are reasonable. That's it. We're not talking about whether or not something is admissible at trial. That all can be determined at a later time. The only issue present, in our opinion, is whether or not this stuff is relevant as to a specific issue, whether or not plaintiff's medical expenses are reasonable from all these treatment providers. And the separate categories of documents identified in our response and identified in the DWQs all show, they can show whether or not something has a tendency to be reasonable or a tendency to not be reasonable. They also will show whether or not there's an objectivity on the part of the treatment provider, or whether or not there's a bias with the treatment provider as it pertains to particular patients in one category or the different category. There's nothing that we are trying to get admissible in evidence at this point. All we're trying to do is proceed with this discovery in this case, which the discovery period is still open for another 3.5 months because the trial date is now in September, with these depositions on written questions and discovery subpoenas. If a patient,
So let me ask you this. I've seen DWQs used in a variety of ways. I will say that I've seen a couple of times where attorneys have tried to do what I think you're trying to do here. I've always quashed those. I have seen them used in other ways. For example, if there's a question about whether or not, and I've seen this happen, where the affidavit did not include all of the relevant medical billing or charges or records. For example, let's say someone went to a medical provider for a previous accident and then went for the current accident, and you try to find out all the records and only the current accident is included. I think DWQs are perfectly okay for that. That doesn't seem to be what you're trying to get at, though. Is that correct?
well, in this case, we don't know, well, to answer your direct question, Your Honor, we don't know whether or not these treatment providers have treated Ms. Gamble in the past. The only thing that was produced thus far is the standard discovery subpoenas regarding treatments and medical billing pertaining to this accident. But we believe that if these medical providers are treating and charging a certain amount to one set of patients and charging a set rate of charges to a different set of patients, whether or not they're represented by counsel, referred by counsel, insured, not insured, whatever the case may be, we believe that if they're charging different rates to different sets of patients, that is directly relevant on the reasonableness of those charges. Whether or not
Mr. Strauss, I disagree with you on that point. So given what you've submitted here, it sounds like you're just trying to do kind of a fishing expedition about to see if there's, you know, by your argument, basically every medical provider, because every medical provider has different contracts with different health insurance and Medicare and Medicaid. They have different rates for each. that's not relevant in this case. It's what's paid and incurred, reasonable and necessary. There's already been an opportunity to file a proper counter affidavit, which was already struck in this case. I'm going to go ahead and quash these requests, these DWQs. I will say that if your real goal is to try to make sure that all of the records and bills were actually provided, and whether or not there was any pre-existing, medical care that wasn't provided, I will usually allow that. I don't think that's what you're doing here. And if you want to send new DWQs that just make sure that's really what's happening, I will usually allow that. The kind of fishing expedition that you're trying to do here is not going to be allowed. So anything else that we have today?
And Judge, they have already issued DWQs that were to these providers last year to get the records showing the treatment. So this is a whole, yes, Your Honor. So this is a whole separate.
Now, just so the record is clear, Your Honor, these particular DWQs that issue today, we believe are expressly permissible pursuant to the NRA North Cyprus Medical Center Supreme Court decision.
I'm familiar with that case. I don't think it applies here.
Okay.
So I appreciate that. All right, guys, thank you so much. We're going to go ahead and end the meeting, end the hearing, and you guys have a great day, okay?
Thank you, Judge.
Thank you, Judge.
And Ms. Chauvin, you already submitted an order on this?
Yes, we did. And I think I'll double check. My paralegal should have emailed Rhonda a courtesy copy this afternoon.
Rhonda, make sure you go ahead and email that to me, okay? Thank you, guys.
Thanks, Judge.